Okay, good evening. Thank you everybody for coming out this evening, and appreciate Jackie and city staff for inviting me out. This is part two of a two-part training seminar that we've done for really all of the boards and commissions for the city, and tonight I've been asked to come in and speak more specifically to the roles of the Planning Commission and the Board of Adjustment and the important jobs that they do for the city. Before I get started this evening, I thought I'd share with you a little bit about my background. I've been a municipal attorney for my entire 18-year career. A little over 10 years ago, I founded Lauber Municipal Law. I had only a laptop, a cell phone, and 4 clients who agreed to come with me. Today we have 7 full-time attorneys, and we practice municipal law exclusively from our offices in Lee Summit and Jefferson City. We serve as the city attorney for 53 Missouri cities, prosecutor for 13 additional cities, and serve as special counsel like we do for the city of Blue Springs for several dozen in every facet of municipal law. Working with the city's administrative and legal staff, we've designed this training program specifically for the city of Blue Springs to address some issues important to the city's operation. And tonight's presentation is the, as I said, whoa, technical difficulties. There we go. I think it feels seated. Is everything still working okay? Great. Tonight's information is the second in a 2-part training program related to public official liability. So we'll be discussing again the specific roles and responsibilities of the Planning and Zoning Commission and the Board of Adjustment. 3 weeks ago, as I mentioned, I presented information more generally for all boards in commission. So I've got a lot of material I'd like to cover, so I'm going to go ahead and get started. You all should have received a packet with some note pages in there that you can kind of follow along with, and then we're going to start by jumping into an overview of land use regulations. And so I'm going to kind of start big and theoretical, and we're going to start to work down to the narrower pieces of the roles of each of whether the Planning Commission or the Board of Adjustment as we go. So let's see here. Yeah, I'm going to go ahead and jump in. So really, again, kind of the background of land use regulations. So in the earliest stages of land use, nuisance was and even continues today to be the baseline rule. And the underlying concept of nuisance is that a person is able to use their land in any way that they wish, as long as they do not interfere with someone else's right to use and enjoy their property. And so you have your old-timey pugilists up here, and the idea here is you know, as individuals, we're all free to swing our arms right up until the point that it hits somebody else in the nose. Okay? And nuisance is very similar. You can use your property any way you see fit, provided that that use does not then interfere with someone else's use of their property. So what's the problem with that? Problem with that is the fact that as a property owner, if you made an investment into property, you had to wait until that crummy neighbor moved in and started doing things that made it difficult for you to enjoy the use of your property. So you bought your beautiful little house with your white picket fence and put your roses in and your swing sets in the backyard for your kids, and then the chicken rendering plant moves in next door and makes it so that you can't even stand the smell of your backyard. Okay, and that was what the rule was prior to land use regulations. Everything about it was reactive instead of proactive. So that also caused neighbors to do what they hate to do, and that is they had to go out and hire their own attorneys to battle whatever nuisance was next door. And neighbors already hate to talk to neighbors. They'd rather come and have the city take care of it for them, wouldn't they? Without regulations, nuisance was a private matter and handled individually. But as we'll discuss further, once populations became denser, there was also a need for a better method for handling these nuisance claims. The Industrial Revolution occurred in the United States in the middle part of the 1800s. society began to shift from production that occurred on a small scale by hand at each person's home to a larger scale through machinery in mills and in factories. As conflicting uses of land and the number of nuisance cases began to rise, cities began to think about ways these conflicts could be avoided even before they started, to think more proactively instead of reactively, as we just described in the last slide. In other words, cities began to plan for growth. What a concept. So we talk a little bit about the goals of planning. With the goals of planning, development occurs in an orderly fashion. It includes uses and structures allowed in a particular area and the timing of development when it occurs. It allows for more efficient construction of infrastructure, and it allows for a more efficient provision of municipal services. The use of property tends to flow smoothly from area to area, and areas are planned ahead to allow certain uses to be gathered in one area to make them more uniform in that area, as opposed to, the chicken rendering plant next to the residential house. Uniform laws called enabling acts began to develop to provide for a consistent framework to be put in place from town to town. New York City had the very first Planning Enabling Act in 1916. Following suit, the federal government created two model acts. One was called the Standard City Planning Enabling Act, and the other was the Standard Zoning Enabling Act. Within a year of that time, all 48 of the contiguous states had adopted both. And within 12 years, there were two model acts in existence that I had mentioned there. Missouri has adopted Missouri has adopted portions of these standard zoning enabling acts as Chapter 89 in the Missouri Revised Statutes. And that's where, when we talk tonight about planning and zoning and Board of Adjustment powers, we're going to be looking a lot at Chapter 89, again, because it is Missouri's capture of those early and original model acts. So planning. What is planning? Planning refers to a city's general policy to guide development. A city's plan for development over time is often called its comprehensive plan. And that is because there may be smaller sections of a city that have their own spin-off comprehensive plan, like you might have a special downtown district, or you may have an industrial park area that is treated a little bit differently. City may also include in that comprehensive plan plans for different types of infrastructure. For example, you might include a transportation plan within your comprehensive plan. You might include an annexation plan. I recommend that my clients include an economic development plan. Say, where would we like to see an annexation plan? Where do we want to see the boundaries grow? Where do we want to see businesses grow? Where do we want to see residential and so forth grow as the city develops? The decisions made today by property owners and elected and appointed officials are very likely to have an effect that lasts a very long time in the future. As you know, I know that Blue Springs takes a look at its comprehensive plan about every 5 years according to city code, and most cities, when they adopt a comprehensive plan, it's usually looking forward about anywhere from 15 to 30 years. One great example of the use of planning is to curb leapfrog development. Leapfrog development occurs when a property owner seeks to prematurely, using kind of quotes here, air quotes, develop a parcel of land, for example, a subdivision. I say premature because in the example I'll share with you, I want you to imagine that this particular parcel that a developer wants to develop is a half mile or more from any existing development in the city, okay? So you may have an area where you've got subdivisions that have grown up and are being produced, and there might be a large, several hundred or maybe even 1,000 acre tract of land, and then on the other side of it you have a developer who's ready to go. And they want to come into the city and say, I'm ready to develop. I want to sell my land and I want to start subdividing it, and I want to turn this investment, I want to liquidate this investment that I have in this land. Well, to do that, It's going to cause the city to have to extend its infrastructure across that 1,000 acres. It's going to cause police trucks and fire trucks to drive further to get to that development. So it's premature to leapfrog out past the undeveloped land, come back. And planning regulation allows the city to help better time that. The creation of a comprehensive plan is where a Planning and Zoning Commission gets to set the rules, and we'll talk about that more later. However, the rules in a plan, I have to tell you, are not strictly enforced. They are considered a guide for development, and we'll talk about that a little bit more as the evening unfolds. The zoning side of things. Zoning provides a means to address the practical aspects of land use at a lot-specific level in real time, okay? Where planning is more uniform and it applies more globally, zoning is going to get it right down to the individual lot and how we deal with those. Zoning is a tool to aid in the implementation of that comprehensive plan. Zoning regulations affect the use of land both by scope, which would be height, bulk, how close to a street, how tall can you go, and the utility of the land. How is the land used in a practical sense? Zoning represents a proactive rather than a reactive approach to protecting property interests. With zoning laws in place, a property owner can now be more confident that they will not be on their own to fight a neighboring property owner who is making an unreasonable use of his or her property that ruins the peaceful enjoyment of that first owner's property. Government code enforcement officers will assist in this effort. They will be able to back up the zoning laws as they come into place, and you don't have to rely on the courts and nuisance to curb those unreasonable uses. In 1926, the United States Supreme Court heard a case that originated from the enforcement of the city of Euclid, Ohio's zoning ordinance. Ambler Realty owned a bunch of property in the city of Euclid. The city adopted a zoning ordinance which limited their ability to sell the property to potential buyers who wanted to use the property for industrial plants. Ambler, the realty company, sued the city because this reduced the value that they felt they could get for their property. In 1926, the United States Supreme Court held that in general, zoning is a valid exercise of local government authority designed to protect the health, safety, and welfare of the public in general. These are commonly called the police powers of government. And I can tell you that as the city attorney for dozens of cities, I commonly hear property owners indignantly declare in meetings that the city cannot tell them what they can do with their property or how they can use it. Wrong. To the contrary, land use regulations controlling how land can be divided, developed, and used have been in effect in the United States for nearly 100 years. Let's talk a little bit about a summary of some of the sources that we covered, or let's summarize some of those. Today, as we mentioned, the city's zoning authority comes from three basic sources. The city's inherent police powers to protect the health, safety, and welfare of the people. That's, in essence, when you boil it all the way down, the purpose of government is that we look out for people from their health, their safety, and their welfare on a uniform basis. Because imagine a world that you live in where you only get a police officer to come to your house if you can afford to pay for it. You only get your fire put out if you can afford to pay for it, okay? It doesn't work at a marketplace level when we're talking about providing for the health, safety, and welfare of citizens as a whole, and that's why we need to pool together, and that's why we have taxation, and that's why we have a source of funds to make sure that everybody is taken care of in that circumstance. Another source of the power we talked about is the state of Missouri's Zoning Enabling Act, which is Chapter 89 of the Revised Statutes of Missouri. And then ultimately, we're going to be looking to the city's planning and zoning ordinances, which are set forth in the city's Unified Development Code, or sometimes you'll hear it for short, the UDO. Your UDO is at Title 4 of the City Code, and it consists of chapters 401 through 411. And so all the rules that we'll talk about here tonight will come from there. And think about this for a second. The standard zoning and the standard planning enabling acts, which are put in Chapter 89 of the Missouri Revised Statutes are what we call enabling acts. You do not have to do zoning. I have a couple of my clients who don't have zoning. They live in that world where the two people are boxing it out over, in nuisance because they don't have zoning in their community. I have one of the communities that when I became their city attorney in 2011, I helped them about a year later adopt their very first zoning code, okay? You don't have to have it. But what we will talk about tonight is you have the ability through Chapter 89 to adopt these regulations, and then you make them fit your own local government, because what really makes sense is, we wouldn't have folks in Jefferson City telling us whether we should have industrial use or commercial use on, 3rd Street. Okay, that doesn't make sense. We take care of that at a local level. And so we'll be talking about the fact that the city has then taken that power from the Enabling Act, brought it down to the city code, and then we're going to be talking about how then you apply those. Okay, so Chapter 89 establishes the authority of cities to plan and zone and provides the methods as to how city carry out that authority. Cities are to follow the rules and procedures that are laid out in Chapter 89. And so I'll point out just a couple of these. Section 89.310 grants all cities the power to make a comprehensive plan. So there's your planning commission, sets forth the contents of the plan at .340, and at .360 we lay out all of the requirements for making an approval or an amendment of a comprehensive plan. I'm going to go over some of these pretty quickly just because, the detail for yours are actually in your code, and I mean, we would be here for 6 hours if we wanted to cover all of that, but I just want to, kind of point these out to you. On the zoning side of the equation, Chapter 89, .020 and 040, so 020 is where cities have the authority to zone. Chapter 89 or Section 89.040 sets forth the purpose of zoning, that we're going to conform those regulations to the comprehensive plan. We're going to provide for safety, adequate air and light, and to avoid concentration of population and overcrowding, and preserve features of historical significance. Again, these are all words straight from Section 89.040, or the statute that authorizes the city to zone. Okay, now that we've covered kind of the baseline of like how did we get here and what are the basic rules at the state level that the city's taken on, I'm going to start to dive in specifically to provisions related to the Planning and Zoning Commission. So, if a city chooses to exercise its zoning powers, Chapter 89 absolutely does require the city to establish a zoning commission. If a city has a planning commission, it may be appointed as the zoning commission as well. Often cities have what are called planning and zoning commissions, P&Z for short, and that's what you have. Section 89.070 falls in the zoning section of Chapter 89, and it requires the city to appoint a zoning commission if the city wants to regulate land use in the city through zoning regulations. And again, in that section, it specifically says that if you have a planning commission, you may also appoint it as a zoning commission. And honestly, that's really the only mention of commission in the zoning section of Chapter 89. In the latter portion of Chapter 89, the 89.300s at 89.390, it specifically says that a planning commission shall perform all of the functions of a zoning commission. So City Code Section 402.020E establishes that for the city of Blue Springs, establishes that for the city of Blue Springs. 89.310 through 89.430, which consists of 13 sections of Missouri statute, provides much more detailed description of how a planning commission works and what what its powers are, which we'll explore in just a minute. So first, what we want to talk about, and you see on the screen here a comparison between state statute and city code, because again, it's an enabling act. You can pull it down and then you can utilize it how you wish. So under 89.320, planning and zoning commissions are authorized to have anywhere from 7 to 15 total members. The City Council for Blue Springs has determined that the Planning Commission will have, I'm sorry, let me back up. So under the state statute, the City Council may have 7 members, the mayor if the mayor so chooses, and a council member if the council so chooses, and then 7 citizens of the city, or at least 5 citizens of the city, and then it can go up to get to that maximum of 15. Planning and zoning commissioners are required by law to serve 4-year staggered terms so that all the terms don't expire all at once. And they may only be removed for the council for cause stated in writing and only after a public hearing. And in order to have a quorum at a meeting, you must have at least 4 members present, depending on how large your commission is. So you see here then on the code section side, that it has been determined for Blue Springs that your commission has 11 members. So you kind of fit right in the middle of that 7 to 15. They must be citizens appointed by the mayor and approved by council. So the city of Blue Springs has chosen not to have the mayor or a council member sit actually in the planning commission. Many other cities actually do that. So if you all are hanging out at the Planning and Zoning Commission Country Club sipping on mint juleps, talking about that, that would be why it's different, okay? 4-year staggered terms apply in Blue Springs, and those it has been set in your code that those terms do expire on April 15th as they expire. All right, so let's talk a little bit about Planning and Zoning Commission powers. City Code Section 402.020C provides that the powers, duties, and terms of office of the Planning Commission shall be designated as in Section 89.300 at SEEK, all of the Planning Commission provisions in state statute. So consequently, instead of talking specifically about anything further in the City Code, we'll jump over to the state statutes. So, what does a Planning and Zoning Commission do? The first major role that I'll speak about this evening is that the commission is responsible for preparing and adopting the city's comprehensive plan. I would like to note for you that it is the Planning Commission and not the City Council that adopts the comprehensive plan. Most councils or boards of aldermen that I work with also do what I would call a ceremonial adoption of a comprehensive plan that indicates their approval of the plan. But as I said, it is purely ceremonial because state law says it's the Planning Commission that makes the decision on the adoption of a comprehensive plan. State statutes requires the commission to make careful and comprehensive surveys and studies of the existing conditions and probable future growth of the city, straight from the statute. The purpose of the comprehensive plan is to guide and accomplish a coordinated development of the city in light of existing and future needs that will promote the general welfare of the city, promote efficiency and economy in the process of development. As I mentioned earlier, a comp plan may be adopted in 1 or more resolutions and may be made up of 1 or more individual plans that correspond to a master plan. We'll talk about the procedural requirements for that in just a few minutes. The second major role that I'll talk about this evening for a Planning and Zoning Commission is to recommend zoning regulations and the boundaries of various zoning districts to the City Council. So in Part 1, it's the thing that the P&Z gets to decide. In Part 2, the Planning and Zoning Commission is a recommending body, and they're making recommendations to the City Council, who sits, as the legislature, because we do have separation of powers at the local level. We have executive, administrative, legislative, and judicial. And so the P&Z kind of sits essentially as administrative or almost quasi-legislative. They're a recommending body to the legislature. The legislature will set the laws, and then we'll talk a little bit more later tonight about the interpretation of those. So in making that recommendation to the City Council, the Planning and Zoning Commission must make a preliminary report on the recommended zoning districts and regulations. It must hold public hearings on the boundaries and the regulations, and it must ultimately make a final report to recommend zoning district boundaries and regulations as that passes through to the City Council to be approved as law through an ordinance of the city. Another important role of the Planning Commission is to make recommendations to the City Council regarding subdivision regulations. Okay, so we've talked about the planning and the subdivision as one subset, and the zoning and the use as another. But on the subdivision regulations, as we discussed before, they're not as much about how land is used, but more about how land is divided and when it can be divided. Planning commissions are required to give a city's governing body recommendations regarding subdivision regulations. And these are in addition to the requirements for plats that is actually provided outside of Chapter 89 in Chapter 445 of the Missouri Statutes. There's a whole nother segment of statutes that deal with platting rules. For coordinated development of the city so these are purposes of again of the subdivision regulations: to coordinate development of the city, to address that leapfrog development that we talked about, to coordinate the streets within subdivisions and within other existing and planned streets or other features of the comp plan, which could again include a transportation plan. To create adequate open spaces for traffic, recreation, light, air, public uses like parks. Comp plan is to help to distribute population and traffic. It can require developers to post a security that the required improvements get done in the form of providing surety bonds, letters of credit, or escrow funds, and can include requirements to the extent and manner in which streets in a subdivision are graded or improved, and also addresses the installation of utilities in those subdivisions. So all of those things are covered in that subdivision regulation section that the Planning Commission will recommend. Additionally, the Planning Commission plays a role in approving plats for individual landowners. Again, plats must first meet the requirements of Chapter 445, that they be drawn to scale, with the scale noted on the face of the plat. They describe the lots for sale by number with precise length and width. They have to give a title of the plat, block section, so we can identify it. Acknowledged by the owner, approved by ordinance of the City Council, signed and sealed by the city clerk. Have to show that taxes have been paid when you approve a plat on the property that's been platted, and that it's in conformance with the comprehensive plan and zoning. All of these are requirements that I'm reading to you that are from Chapter 445. Once a plat meets those requirements of 445, it is submitted to the city for approval, and the city subdivisions regulations establish that approval process. So again, the approval process is normally as follows. You submit a proposed plat for initial review. Planning Commission holds a hearing on the plat to ensure it meets the requirements. And then we talk about the preliminary platting process as we go through. So again, all of these requirements are come from Chapter 89, and then you have I'm sorry, go ahead.
Are we issued a Missouri law book? This is pretty intensive, and you're covering it pretty generic.
Let's see. Do you guys need him to come to the front here, or how does that work with the?
No, I don't think so. We can hear.
Oh, I'm getting the signal from the back that he can't hear the question for the. Yeah. I'll just repeat the question. So the question was, will everyone be issued a Missouri law book? No, typically that's not the case, and I'll let Jackie, correct me, but commonly what will happen with respect to all of these requirements is that's what city staff is for. City staff will take applications. They will have researched the law for you. They commonly will lay that out in a staff report that you get ahead of time to show that all has all been met. In almost all of the cities that I work with, from a city staff standpoint, we don't as staff, we don't even let applications come through for consideration if they haven't already towed the line, if they haven't met the requirements ahead of time. There's no sense in wasting an applicant's time or your time as a commissioner to bring an application forward to have it fail just because it didn't meet some of the statutory requirements. So from that standpoint, that's where you rely on the city's professional staff to make sure that when those applications come forward, they're very complete. And then that's something that you don't have to worry about. But I wanted to talk about it tonight because many times you crack that packet open and you don't know what it took to get it there. Okay, and so I'm trying to describe for you all of the things that are happening in the background, and then what staff does is makes life easy for you to have it teed up and say, here are the things to look for. So when you get that staff report, don't crack it open the meeting, the night of the meeting, right, when you get there. When you get that staff report, open it up, read through it, make sure you understand it. If you have questions, send a question back to city staff so that they can resolve it. There's nothing worse than getting to the meeting and waiting, playing gotcha, or just waiting until it's too late, and maybe they could actually research some information that would help you make the best decision possible. Because when it's all said and done, our jobs as city staff is to do exactly that. We want to make sure that you as volunteers for the commission, the board, or the elected officials of council, we try to make their jobs as easy as possible. And when I say easy as possible, what it means is we want to give you all of the information that you need to make the best decision or make the best recommendation to the city council, depending on your role, that you possibly can. And that's what we're here to do as city staff, is to serve those interests. You probably asked me how to build asked me what time it was, and I told you how to build a clock. But yes, ma'am.
I was just going to say the Missouri revised statutes are online, though. You can just Google.
Okay, yeah, and so the comment back was that Missouri revised statutes are online. If you go to the Missouri Reviser of Statutes, it's usually one of the best sources to get the Missouri statutes. You want to look at that, and Chapter 89. If you have insomnia, it's a perfect cure. Print that out, read them every night. You'll be out in a heartbeat. So, okay. So let's talk about a few more powers of the Planning and Zoning Commission. Planning and Zoning Commission is charged in Missouri with approval of infrastructure improvements, recommendations relating to the plan and development of the city, and recommendations on plats where they affect the city's major street plan if you have one. Planning and Zoning Commission is also involved in the city's approval of infrastructure improvements. Once a plan has been adopted, no street, public facility, nor any public utility may be installed without first submitting the location, extent, and character of that improvement for approval by the Commission. If the Commission does not approve the improvement, it must communicate the reasons why to the City Council, and the City Council may still approve the improvement by overruling the Commission, but this can only be done by a 2/3 majority vote of Council. The same is true for the following actions related to infrastructure improvements, which include acceptance, widening, removal, extension, relocation, narrowing, vacation, abandonment, change of use, acquisition of land, or sale or lease of land. One of the things to keep in mind that many of the applications that come forward to the Planning Commission, if the Planning Commission fails to act on those applications, they are deemed approved after 60 days. 60 days. That's one of those things that staff knows. They know that clock starts, and so they will get that information to you as quickly as possible so that you can get that approved before the deemed approval kicks in. So let's talk about plan approval. As I mentioned earlier, we're going to talk about those procedural requirements for adopting a comprehensive plan. The city code doesn't say much about the comprehensive plan except that it must be prepared according to state statutes and that the city administrator is required to bring a plan forward every 5 years. So consequently, again, we'll look to the statutory requirements for a comprehensive plan, which are found at section 89.360 of the Missouri Revised Statutes. So Planning Commission must hold a public hearing regarding the plan. Prior to that public hearing, the city must publish notice of a hearing in the newspaper of general circulation within the city at least 15 days in advance to let people know the time and place of the hearing. At the hearing, I will say that it is a best practice to have city staff and consultants give a summary of the proposed comprehensive plan to ensure that anyone from the public in attendance has an understanding of what it is that you're trying to accomplish. Once the city staff or consultants have made their presentation, the commission will then open the door to individuals from the public to hear their comments about the proposed plan. Once the public is done speaking, the commission will either close the hearing or they might continue it if they believe that more information is needed to address the issues that have been discussed. Once the issues have been resolved, the commission closes the public hearing and votes on whether to adopt the comprehensive plan. In order to approve a comprehensive plan, a majority of the full commission must agree. Since this is an 11-member commission, there must be at least 6 yes votes to approve a comp plan. And this is regardless of the number of commissioners actually present. So remember, with an 11-member board, it only takes 5 members to constitute a quorum. And so, but it takes 6 to approve a comp plan. So if you ever had a night where, and hopefully you don't have this, but if, you had a bare quorum show up, 5, and you were there to consider a comp plan, it can't be approved that night, even though you could conduct other business. So keep those kind of things in mind. So, I'm sorry?
The quorum would be 6.
I'm so sorry. Yes, you're right. It is 6. I apologize. Got my numbers off. Yeah, a majority of the full commission, 6 and 6 on that. Yep, okay. Let's see here. Once the commission's resolution has been adopted, 2 important steps must occur. The commission must sign the comp plan, the comp plan must be signed by the commission secretary, and a certified copy of the adopted plan must be filed with the city council and the city clerk, and the commission must file a copy of the plan with the county recorder of deeds. And in this circumstance, it's actually the actual copy that must be on file, not just the resolution. And also a copy of the plan must be available to the public at City Hall. And so failure to meet these statutory steps can actually later cause the city's zoning ordinances to be declared invalid. So again, sounds serious, but that's city staff is there to help make sure that all that gets accomplished. For our last topic of discussion with respect to Planning and Zoning Commission, we'll discuss the procedural requirements the Planning and Zoning Commission must follow when recommending zoning regulations to the City Council. The zoning requirements in the statutes aren't as detailed as the Planning Commissions that were added later. So we briefly touched on the earlier, so they may look familiar. The city's zoning regulations must be made in accordance with a comprehensive plan. The comprehensive plan needs to include both how land is to be used and how it can be divided or improved. When the city approves original zoning regulations, the Planning and Zoning Commission must first make a preliminary report on the proposed regulations. State statutes require the commission to hold a public hearing on proposed regulations. Then the commission must prepare a final report for submission to the City Council to recommend districts, district boundaries, and other regulations. The City Council is not permitted to hold its own public hearings or take any action regarding original zoning regulations until it first receives the commission's final report. Chapter 403 of the City Code consists of all of the procedures for review of development applications, and Section 403.010 addresses the general requirements for all applications. Okay, for a moment, let's talk about conditional use permits. A conditional use, or sometimes it's referred to as a special use. Sometimes you'll hear that SUP or CUP, conditional use permit, special use permit. Here in Blue Springs, you refer to it as a conditional use. It is a use that is one that is permitted in a zoning district following a specific review and approval based on enumerated requirements and subject to certain conditions that may be imposed. So typically what it would be is a more intense use of a piece of property that does fall within the permitted use in that area. So maybe an example of this would be you might have a commercial district, we'll call it C1, where you allow commercial businesses to occur. Well, the use for a commercial business like a bookstore is, going to be fairly light. It's foot traffic. It's probably, moderate to light traffic flow that would go there. Now, if you turn, that if you consider, a bookstore versus, a large, a big box home improvement store, okay, that's going to have a much larger square footage. It's got a lot of foot traffic. It'll have a lot of semi traffic, delivering goods, taking goods away, things like that. They're both retail uses. One is much more intense than the other, and typically where a conditional use comes in is when you have a more intense use, then we're going to take a little more specific and focused review of that use, and that's a use that oftentimes will require a conditional use permit to make sure other things are taken care of. We talked about Planning Commission needs to plan for infrastructure related to the development. So on a higher traffic, and when we talk about not foot traffic but actual vehicle traffic, in that circumstance, that may be where Planning Commission would recommend there needs to be a turn lane or an additional stoplight or something like that would be put in conjunction with a development that's going to have higher vehicle traffic as opposed to something that's going to not have very much vehicle traffic at all. So allowable conditional or special uses are identified within the regulations of the zoning district, and so you have to review those applications for conditional use permits. And so when you're reviewing those applications for conditional or special use permits, you're acting in an administrative capacity, which we're going to talk a little bit more about the different capacities. So we've got kind of that background now. We have the big picture of like, why do we have land use regulations? We talked, about, how do we get a planning commission, kind of what's the baseline for a planning commission? Now we're going to jump over and talk about what is the baseline on Board of Adjustment. So kind of, again, starting big and trying to focus down. While a city enjoys the authority to enact zoning regulations, which we've talked about up to this point, there are constitutional limitations on that power. So if a regulation that is adopted by the city's legislature, the city council, goes too far and makes it so that a property owner loses the ability to make any reasonable use of their property, then that regulation could be declared void as a taking of property without just compensation. So we, it's basically called a regulatory taking. Like where you might be familiar with eminent domain or condemnation, where a city actively goes out and says, we need this piece of property to put in, utility easements, or to put in a road, or to, do, something where you've seen cities do that, where they're actively taking property, which they're allowed to do through eminent domain. This is not that situation. This is a situation where when we were adopting laws that were generally applicable to everybody, there's a potential that that law, when you focus it in on one specific lot, that it could have had the effect that you might as well have just taken it because now they can't use it at all. Okay, and so that's the situation that we're talking about. So the right to just compensation for a governmental taking of property is found in the Fifth Amendment to the United States Constitution, so applicable to the states and therefore the cities through the 14th Amendment. So to reduce the effect that a regulation, when adopted, might in certain circumstances create inverse condemnation or regulatory taking, the state enabling acts require cities that exercise zoning authority also to create a Board of Adjustment. Okay, so again, the Board of Adjustment exists, and in that bottom diagram there is a safety valve, and that's exactly what the Board of Adjustment is just in case laws that are passed by the city would be too restrictive on a particular piece of property. The Board of Adjustment exists to relieve pressure in that circumstances. So again, hearing before the Board of Adjustment serves as a safety valve to address the situation before the property owner sues the city for a regulatory taking. So section 89.8080, so 89.8080 .080 requires that any city that adopts zoning must appoint a board of adjustment. This statute also states that the city may give the Board of Adjustment authority to make variances to the application of zoning ordinances. So that's kind of interesting, and we're going to get into that just a little bit. Okay, so that Enabling Act, I'll say it again, you have to create a Board of Adjustment, but you don't have to give it the ability to make ordinances. Seems funny. We're going to get into a little bit of the why here in just a minute. Chapter 89 does not require the variance procedures, but many cities choose to have their boards of adjustment exercise this power as a means to create that safety valve we were talking, to reduce the amount of litigation filed for those regulatory takings. So let's go over some more of the general provisions related to the Board of Adjustment. So first, boards of adjustment are statutorily required to have 5 members, and they may have 3 additional alternate members. City Code Section 402.030B establishes the Blue Springs Board of Adjustment as provided by statute. Okay, so it says as provided by statute. So with a 5-member board, to have a quorum at a meeting, you must have 3 members present. This can be problematic, and I think this is exactly why I made the mistake earlier on the quorum thing, because it's a bigger deal when it comes to Board of Adjustment. So again, with a 5-member board, you have to have at least 3 members present to have a quorum, and then you can conduct business with 3 of the 5 there. However, state law requires that you must have 4 members vote yes in order to approve a variance. So you could actually have a meeting convened where you can conduct official business of the Board of Adjustment, and the applicant may be coming forward for a variance, and if you only have those 3 members there, then even if everybody voted yes, you couldn't approve that variance that evening. And in fact, I'm the city attorney of Grain Valley. We had that very thing happen, I think it was a year ago in the fall, where we had an application come through, and we got there, and only 3 showed up. So we could open the meeting, we could approve the minutes, we could do, all of that. But I needed to have a sidebar with the applicant's counsel beforehand to say, hey, you guys might want to ask for a continuance this evening, because even if they all vote yes, you're going to lose. And so they did, that very thing. So it's important, if you've accepted, the mayor's appointment as a Board of Adjustment member, show up to those meetings. It's really important. Okay, so one of the things, so I'm skipping through some notes that I kind of covered ad lib right there, but so real quick, just kind of coming back, a member of the board who was not present may listen or read to proceedings at a hearing and review all the documents and still vote. So if let's say you have Board of Adjustment and you hold a public hearing on an application, but you decide to either continue the hearing or you close the hearing, but you decide not to vote on it that evening. A member who was not in attendance can review all of the documentation for that and still vote later. Okay, so I just wanted to touch upon that as a possible fix if you have a situation where you have less than a quorum. My recommendation would still be, if you have less than a quorum, ask the applicant if they can continue. Okay. Talking a little bit about Board of Adjustment basics here, and what I'm kind of getting at here is what I would call those kind of pitchforks and torches meetings that can happen from time to time, where people are really riled up and they come in, they're very angry, or people are divided on how it goes. So one of the things I always want to remind, and this really applies to the Planning Commission chairman as much as it does BZA, or I'm sorry, BZA's Board of Zoning Adjustment, your Board of Adjustment. So, but because of the nature of a Board of Adjustment hearing when they're had, they can be more contentious. They are truly treated much more like a contested case type of a hearing. And as we'll cover a little bit, a Board of Adjustment is essentially sitting as judges. We call that Board of Adjustment is a quasi-judicial, it's administrative, but it performs a judicial type role when it does what it does, which kind of puts people in opposition addition to each other. So always remember that the chairman presides over the meeting and has control of the meeting's conduct. It is completely permissible to impose reasonable time limits on speakers and to ask those who are simply providing repetitive information to talk about something different or sit down. I will tell you that if you have formal and regular procedures that help you keep in control of meetings, that's a must. And I always tell people that I work with, you should, no matter what it is, whether it's city council, whether it is the planning commission, whether it is the board of adjustment, that you should have those procedural rules and keep them in place. And I always say, keep them in place when times are bad, because you'll be thankful for that when times are good. Or when, I'm sorry, whoa, backwards. Sorry. Keep them in place when times are good, because you will be thankful for those when times are bad. Because what can happen is, you may have rules that say speakers may only speak for 3 minutes, or, we're going to ask people who, are saying something that's repetitive to move on to a different subject, because it's been noted or whatever. But if you only pull that rule out when there's an angry mob in front of you, they're going to basically say, well, you're only doing that because we're here as an angry mob, or you're restricting my views as a speaker because you don't normally do this. You don't, hit the buzzer at 3 minutes or whatever the case may be. So I think it's incredibly important that any board, especially ones that have public hearings, set those rules in advance and always enforce them. Make sure they're very clear. I would print them out and have them available before every meeting. It will completely help you when things go bad. So again, if you haven't adopted rules of conduct, you should, and that is provided for both at the Planning Commission and at the Board of Adjustment level. The statutes do provide that you can create your own rules of procedure. I think you should put in formalities like having all questions presented to the chairman and then asking the chairman permission to speak on an issue. And so oftentimes, I got a thing in my hand, but oftentimes I do this motion when we talk about that. So when a speaker comes to the microphone at a public hearing, that should be directed to the chairperson. We'll pretend that I'm the chairperson kind of sitting in the middle of the dais, okay? But if a commission, a planning commissioner or a board of adjustment member or even a city council member, if they have questions, they should refer that back to, whether it's the mayor or the chairman in whatever case, those questions should come back to there, and then the mayor can, or the chairman can then put that question out. And sometimes that's a question that, goes over to staff. That might be a question that's directed to an applicant, but if you create those rules of formality, it helps to keep decorum. Because, again, if you've ever been in a meeting where the pitchforks and torches come out, there's people shouting from, everywhere in the room, and it's hard to maintain control. And sometimes you just have to get to a point where you have to call a timeout. But I think, again, if you can kind of keep those rules in place, as you go, it will help make the meetings more productive and more efficient. Especially when we're talking about, in particular, either planning commission, when people are looking to develop, there's a lot of emotion because it's their property. It might be their huge investment, and they've usually invested a lot of money through getting engineers or having people draw up plats, things like that. And when you're talking about board of adjustment, you're talking about somebody who says, I live in a residential district. I should be able to build the deck I want on the back of my house. Who are you to tell me that I can't build that deck, an extra 3 feet out? And people get, this is their most prized possession usually. It's the most, the biggest investment they've ever made in their life is their own house, and so they start to get very emotional about the decisions that are being made. So again, keep that in mind when you're dealing with folks. So if I've got board members here who have never been at a meeting, I hope I'm not scaring you to death. It's really not that bad. It occurred to me for just a second. It can get serious, and so that's why I want to have these conversations ahead of time so that you're prepared. They're usually very easy and not much to them. So okay, so let's talk a little bit about Board of Adjustment powers. So Section 89.090 of Missouri Revised Statutes gets into the details of the powers that a city can give to its Board of Aldermen. So we talked about before, a city may authorize its Board of Adjustment to hear appeals from decisions of city employees enforcing zoning ordinances. The city may have its Board of Adjustment hear and decide on matters provided by any ordinance. And then probably most familiar to all of you is that the Board of Adjustment has the power to make a variance to the application of the city's zoning ordinance requirements. Over my career, I've represented a lot of cities, and one of the first cities I spent a significant amount of time working with the Board of Zoning Adjustment, in their case, is the city of Oak Grove. And what I can tell you is if you went over to Oak Grove and looked at their code, their Board of Zoning Adjustment over there handles anything that deals with what I would call a contested case hearing. So if it's a situation where somebody, is coming in to say, I need to present my case as to why you should decide it this way, and, there's somebody else over here saying, no, you should decide it this other way, and that other person could be a neighbor, it could be a staff member, whatever the case may be. In any circumstance like that, Oak Grove has their Board of Adjustment do that. Now, not all cities do that. So again, if you're out at the Board of Zoning Adjustment Country Club sipping on your juleps, you may not hear that everywhere, but you'll understand why I'm getting there because of what Section 89.090 provides for you. On variances, it's important to point out that this statute, 89.090, says that when an appeal is brought before the board to vary the application of the ordinance's requirements, if there are any practical difficulties or unnecessary hardships that stand in the way of carrying out the strict letter of the ordinance. And you see that practical difficulties and unnecessary hardships is highlighted there. This is critically important with respect to the Board of Adjustment. Variances are so those are highlighted because the statutes truly allow for two types of variances to be issued, and there are standards for determining whether a variance is necessary, and these standards that are highlighted there will apply to the type of variance that is being sought. We're going to get into this in a little more detail here in a second. So variances are granted when the unique character of the property, and so I'm going to parenthetical this, real quick, is that this is not any sort of a personal consideration of the landlord or the applicant or their situation. So it has nothing to do with the owner's plight, if you will. It has everything to do with, is there something about this property that makes it so that we're going to have to vary the ordinance, okay? What the owner, wants or is worried about or what their concerns are doesn't concern you, okay, when you're looking at doing that. So again, variances are granted when the unique character of the property means that strictly applying the ordinance would result in an unnecessary hardship. So Missouri courts apply the practical difficulty standard to one type of variance and the unnecessary hardship to the other type of variance, which we'll get into. Okay. So let's talk about that now. So there are two types of ordinances. One is a use ordinance, and the other is an area ordinance, okay, or a non-use ordinance. I'm sorry, I said ordinances. There are two types of variances: use variances and area variances. Sorry. Okay. A use variance would allow activity in a certain zoning district that is otherwise prohibited by the zoning ordinance. Okay, so if in an R1 district, keeping of livestock is prohibited, to allow someone to operate a chicken hatchery or something like that by variance is essentially allowing something that is otherwise prohibited. Okay, so you can understand the importance of a use variance. Okay. An area variance or a non-use variance allows for a deviation from a restriction that's placed upon the permitted uses within a district. So an example of an area variance would be a deck or a storage shed may be a permitted use in the backyard of a residentially zoned property, but restrictions on that use, that residential use, includes setbacks from the side yard and the rear yard. So you've dealt with setbacks, and so when we're dealing with setbacks, then what we're getting at is a area variance or a non-use variance. We're not talking about how the people are using it, we're talking about where they place the uses on their property. Okay, so again, I talked about the fact that, the two different standards will apply. So Section 89.090 also establishes baseline standards for granting ordinances, or for granting variances. If a variance is granted, it must be in light of the spirit of the ordinances that have been varied. Okay? So if, the idea of the variance was to restrict a certain use, the spirit then was to be somewhat constricting, and so whenever you make a variance, you have to be keeping that in mind if you make a variance. You have to always consider public safety and welfare when you are considering a variance. Like, is anything that you would do here, would that hurt public safety for any reason? And another requirement is that you must do substantial justice. And so what does that mean? Well, that means you need to be very fair to all that are involved with respect to that. And that's just one element, it's not the whole thing. So let's talk about area variances. So drilling down a little bit further, variances allow for that deviation from the restrictions that are otherwise placed on permitted uses in a district, in a zoning district. So area variances are treated differently than use variances under the law. So Missouri's courts have provided additional information on how these statutes work through their interpretation of the statutes in cases that challenge the grant or denial of variances. So the first thing that I really want to impress upon Board of Adjustment members is that there is a long list of cases that say in Missouri that the power to grant a variance from a zoning restriction should be exercised sparingly and only under exceptional circumstances. So when we talk through the standards that we're about to talk through for the granting of a variance, what I would tell you is, since our power to grant a variance flows through the statute, what it really means is, unless you can check every box for every element of granting a variance, then you don't have the authority to grant a variance in the first place. And if that gets reviewed by a court, they will invalidate your action. Okay, so you need to be careful about that. And again, I'll go back to it. This is a direct quote from a Missouri case. The power to grant a variance from zoning restrictions should be exercised sparingly and only under exceptional circumstances. For a Board of Adjustment to grant a variance, the applicant must submit competent and substantial evidence to prove that the practical difficulties exist with enforcing the regulations on the property that would not allow the owner the full use and enjoyment of their property. So I'm going to come back to it. Board of Adjustment is quasi-judicial, okay? You're sitting as judges, and it's the applicant's responsibility to bring evidence to you that for some reason, something about their property, like on a variance, creates a practical difficulty that does not allow them to fully enjoy their property. So some factors that Missouri courts have said are relevant to the grant of a non-use or area variance is how substantial is the deviation, the variance itself, in relation to the requirement. Okay, so if you've got a 10-foot side yard setback and the individual wants to encroach on that setback by 9 feet, well, that's a 90% variance. Okay, now if they only want to come in 6 inches, right, that's a 5% variance. So that's one of the things that you can look at if you're going to grant a variance with respect to an area variance. Another thing that you can look at is whether there will be a substantial change in the character of the neighborhood or a substantial detriment to adjoining properties by granting that. Can the problem be corrected by a feasible alternative in the grant of a variance? And can you achieve fairness to all by allowing the variance? So throughout my career, I'm always kind of looking for good examples because, again, you're not supposed to issue variances very often in the first place. But I will look at the situation. I try to find good examples of that, and I actually had one of my own just this last year. So I live on a rural residential lot. So I live in the city of Lee Summit. My lot is 5 acres in size. Okay, But my lot is it's the planner's bane. It's what they call a piano key lot. And so my lot, even though it's 5 acres in size, it is only 160 feet wide, and it stretches back about 1/4 of a mile. Very narrow. Well, in the city of Lee's Summit, there are side yard setbacks and my property happens to be zoned ag, even though I use it residentially, so it's an ag zoning. So ag zoning on acreage lots in Lee's Summit require a 60-foot setback from the side yard. My property is 160 feet wide to begin with. So that pretty much means I can only build on this tiny little strip right in the middle of it. And as I was analyzing this to get ready to go seek my variance with the city of Lee's Summit, I realized my house doesn't even fit in the side yard setbacks as it stands right now. And then because I live in a more rural part of Lee's Summit, I'm actually not on the sewer, I have a septic line. And guess where that septic line sits? Right in the middle. So for me, I truly had a practical difficulty, because if I was going to obey the statute for rural property, for residential, acreage property, I had, a very small and narrow piece of the center of my yard where I could put, I had a accessory building that I was putting in. And the only place it would fit was essentially over top of my septic line. So there is something unique about my property that allowed me to get an area variance to move it closer to my side yard. Okay, so that's a good example. So if you're ever dealing with area variances, think of me. So I just kind of walking you through that. Okay, so let's jump from area variances to use variances. So first thing I'm going to say about use variances is that some jurisdictions actually take the position that use variances are illegal because they delegate legislative authority to non-elected officials. So again, remember what we said when we were first starting to talk about variances is in the circumstance of a variance, what you as a Board of Adjustment is doing is you're essentially giving permission to bend the rules, right? To allow something that isn't otherwise allowed, that the City Council said, here's the rules, follow them. But then somebody comes along and says, but mine's different. I need a variance. And so this is why courts are saying, no, you only do this very sparingly, and you only do it in the circumstance where the only other option would be that the person cannot use their property, essentially at all, can't make reasonable use of their property. So on a use variance, be very careful. And I will tell you, like I did this training for the City of Independence several years ago, and when I was preparing their information, I realized that their city code, they actually do not permit use variances in the City of Independence. They only offer area variances. So something interesting here. So looking at your code in order to prepare for tonight's presentation, what I identified is the fact that your code actually does not specifically distinguish between area variances and use variances, okay? You won't find those terms in your code if you're looking for it. But what I can tell you is if you look closely enough, and now that you've seen the statutory language, you can see clues. And the clues is both standards, they are listed in the section on variances in your city code. It says practical difficulty and unnecessary hardship. So when you see both of those terms being utilized, then what you can know is that you have at least infer, you have implied authority to do either kind on that. So what I will tell you is, and kind of back to your question previously about, how do we know or whatever, that's going to be, again, the job of city staff to say, okay, this one coming in is an area variance. We know we got to apply the practical difficulty standard. Here are the things you need to look at to get that. And if this is a use variance, then we're going to apply the unnecessary hardship standard, and we're going to ask you guys to ask questions that are, kind of geared to that. So what and I just kind of, gave it away here, but the unnecessary hardship standard is the one that applies to use variances. This is a stricter standard than practical difficulties. So even though area variances should be sparingly given, what this means is use variances should extremely sparingly be given, okay? And maybe never. I was talking with Mike earlier tonight, and he asked me if I could give him an example of a good, strong, valid use variance, and it's difficult to do. The one that we kind of came up with as I was kind of walking down here to prepare was, and maybe you guys have run into this, you're aware that medical marijuana is now authorized in the state of Missouri, and there's been a huge push for how to deal with the zoning for that, because nobody had zoning that permitted medical marijuana before a couple years ago. And so we were busy as city attorneys getting that put together. And so what you might also remember, if you followed that at all, is that most of the medical marijuana uses were restricted in how close they could be to a school, to a church, to other uses. And so if you think about it, if the medical marijuana, let's say it's a dispensary, is a retail location, it's probably going to be in a C district, C1 or a C2. And if your C1 or C2 districts are only in certain places in the city, and all of those happen to be within 300 feet of a church or a school, now you might have somebody that said, okay, I've got this license that this, like I'm one of the very few people, and it's a lot, but I mean, I'm one of the few people that has a license, and I can only go in a commercial district because it's a retail, but all of your available commercial districts don't allow my use to occur. I can't utilize my license, and therefore you've essentially invalidated my license. And the other thing to keep in mind, and Mike, this is an additional factor on that, is that the state licenses are address specific. So it's not even like they could go find another piece of property in town. They have to use the piece of property that they applied for the license for. And so that might be a situation where a use variance might be in order to allow that to occur and not hurt their economic use. So, okay, so Missouri courts have interpreted the unnecessary hardship standard to mean that the refusal of variance would amount to a denial of any permitted use under the ordinances. Okay, so again, very strict standard. Courts have also said these variances should only be issued where the problem caused is by the unique character of the property, that the land won't be able to yield a reasonable rate of return if used only for the purposes allowed in the existing zoning district. It cannot be a self-created problem. I don't know how many times I've looked at variance applications and it's just pretty much because the owner wants it. Okay, that's not something to consider. And also that the grant of the variance will not alter the essential character of the locality. Cover for just a minute that boards of adjustment can issue conditional variances. That's authorized. So that provided that you get the information that you need to establish your authority to grant a variance, that you've checked all the boxes, you are authorized by state statute and by city code to place conditions on the variances that you grant. You may find it necessary in order to act with the most fairness to place additional safeguards and restrictions on the operation of a variance. So you can say, we'll give you the variance, but here's a condition. You can't, whatever your situation that you're trying to take care of, just so that you can help to mitigate the potential bad effect on a neighboring property owner. Okay, let's talk about the implications of the judicial review provision. So what I will tell you that as you're holding a public hearing for a variance, the questions that you ask as a Board of Adjustment member and the answers that you are given are critical for building the record necessary to provide the authority needed to grant a variance. Okay, so I've mentioned before this evening that the Board of Adjustment sits as a quasi-judicial board. You're sitting as judges. You're essentially taking evidence, and then you're going to apply the evidence to the case at hand to make a determination, an interpretation of the law to determine whether a variance is authorized or not. It does require in the statutes that a reporter be available to take that case and to record the case, the public hearing while it's being presented. Something that I haven't covered in a lot of detail at this point, but it's the point of this slide, is the fact that once the Board of Adjustment makes a decision about what to do about a variance, that decision is not appealed to the City Council. If an appeal is taken from a Board of Adjustment decision, that goes straight to the Circuit Court. A judge will make the determination of whether you made the right choice. And what I will tell you, and again, I've referred to this a couple times as a contested case, is you are affecting people's rights, and it goes all the way back to that first nuisance slide, right? Because when you allow a variance, you're allowing one neighbor to do something that was not permitted on their property. So you have the opportunity to offend a neighbor somewhere, right? And so whether you say yes to the variance, you might be ticking off the neighboring property owner. If you say no to the variance, you might be ticking off the applicant. So you're in a situation where virtually every decision that you make could be appealed to the circuit court. And I'll go one further. Many, and I don't see a lot of these anymore. It seems like land use cases in general have kind of fallen off in the last like 10 or 15 years. But when I very first started in this, they were all the rage. Oftentimes, the grant of a variance, when there is a challenge to that grant happening, it is actually the city itself that sues the Board of Adjustment. Okay? And we'll think about that for a second. Remember what I said about why independents and why some cities don't allow use variances. It's because they think it could be considered an illegal delegation of legislative authority. So when your city council says, here are the rules for zoning, and then you as a Board of Adjustment go out there and say, nah, not for that one, that has the opportunity not only to tick off the neighboring property owners, but it could tick off your own governing body. And so there are very many examples out there of cases where a city sues its own Board of Adjustment for a decision that it makes. So, I kind of underscore this, and again, I hope I'm not scaring anybody off and they're going to put their resignation or anything like that. Don't do that. It's a very, it's a very interesting, I think, component of land use regulations. That's probably why I spend so much time on it. But there are a lot of procedural kind of, traps, I guess, in it, and that's why I also wanted to spend the time on that. So, again, it's important that the city, that the Board of Adjustment, pull out of the applicant the information necessary to decide whether or not you have the variance. And if they don't carry their burden, if they can't prove their case, then you shouldn't grant the variance.
Joe, we have about 15 minutes.
Okay, let me hurry up here. Okay, yep. So I'm going to kind of pick it up so that in case there's questions, we can get to that. Real quick, we're going to talk about discretion in zoning decisions. So I've talked a lot tonight about legislative and quasi-judicial. Zoning decisions are out there. So remember, the legislative decisions are those that are made by the legislature of the city. So that's the city council setting the rules that apply to everybody. Quasi-judicial are going to be interpretive, and they're going to be more specific to individual property owners. And so depending on, legislative decisions have a lot of discretion. Quasi-judicial is much more limited by the statute. Back to the Planning Commission side of things, the more creative you get, and actually this is a great, I think I stole this from the city staff on this, is that when you're being more creative and you're doing things like comp plan and text amendments, you have a lot more discretion because that's more on the legislative side. The closer you get down to applying something to the specific lot level, then the less discretion that you have. And so when you have less discretion, then there's more chance for appeals and challenges, and more chance that you'll lose those if they happen. Legislative decisions are under a fairly debatable standard. So essentially, what that means is you have to have, you cannot, it has to be fairly debatable. So you have to have at least some sort of reasonable purpose for the legislation that you pass. And it's only going to be reversed if you were acting arbitrarily or unreasonably. So it's, essentially what that would mean is it's not based in any sort of, there's no standard, no reasonable basis for creating a restriction. Discretion might be limited by state statute, and that's what I just spent some time kind of impressing upon you as Board of Adjustment is you only have the authority to issue a variance if you meet certain requirements, and so that limits your discretion. Something to keep in mind with respect to variances do run with the land, so they are not personal to the property owner. Remember, when you make the decision on a variance, it's got to be focused on the fact that there was something unique about the land. It has nothing to do with the property owner, and that variance will continue. So I kind of say it's written in stone when you do that, so be aware of the lasting effect. 89.110 does talk about that judicial review of decisions. Again, it's treated as a contested case. So once the Board of Adjustment makes a decision, within 30 days, an applicant or anybody looking to challenge that decision can bring a challenge to that, and that will be brought in circuit court. So, as I was talking before, whether you grant or deny a variance, somebody's not going to be happy potentially, and so any decision that you make has the potential of creating an appeal. So don't just do it to appease an applicant. Don't just necessarily do it to appease a property owner. Make sure you do the homework and take a look at the actual requirements before you can issue that variance. So I want to spend just a couple seconds here talking about some general considerations with respect to kind of the overview. So one of the things I want to get into, and I know city staff had provided training in the past, and maybe it will be a good time now that this has been teed up to do something like that again, but your city code, chapter 403, is extremely thorough in setting out the review criteria for all of the various types of development applications. So kind of back to your question is, do we get a statute book? Not only would you have a statute book, but you would actually want to look to chapter 403, depending on what type of decision you're being requested to carry out. And you'll see text amendments. There are 5 different criteria. And so every number that you see there in the parenthetical at the end actually tells you about what does the checklist look like in order to make sure that you've done that. Now, the other thing that's important about applying a review criteria is don't color outside the lines, okay? You learned that in kindergarten. Keep it within the lines, because if you start considering things that aren't within those 10 or those 8 or those 9 review criteria, that's when you open the door to the city's liability for being, more arbitrary or capricious. Because, if you bring in, if looking at the aesthetics of the building for some reason isn't applicable to the type of application that's in front of you, when you start looking about how pretty it is, if that's not one of the 5 things you're supposed to be looking at, then you've opened it up to being an unreasonable decision. So be very careful and make sure that you stick to what you have for you in 403, and that's the stuff that staff will serve up to you when you have an application to say you need to look at these 8 things or those 10 things. Issues related to public hearings. I want to be very careful about a couple things. Number one, be careful about ex parte communication. So what is ex parte communication? It's when you're having a conversation in a, especially in a contested case with one party and the other party is not there, okay? Now, what I will tell you is that, that when it comes to making a legislative decision, ex parte communication is actually okay. Okay, what do we call ex parte communication in a legislative format? Lobbying. Very good. All right, y'all. A+ for all of you. So that's lobbying is ex parte there. If you're a Board of Adjustment member and you have 2 parties, that are at each other, you're at the grocery store and party A walks up and starts talking about the case, you got to get away from them, tell them, sorry, I can't do that, save it for the hearing. Okay, so be very careful about that. Be careful about prejudgment bias. Don't be out there, if you're getting ready to make a decision on a zoning application, don't be out there talking about, on like Facebook or wherever else about the horrific nature of beehives in the city or something like that. You don't want to, be doing that. Now, again, the more legislative that you are, it's better, okay? I won't say it's completely okay. I think you should be careful about that when you're serving these roles. But if you're on the Board of Adjustment and you're out there saying, something that's basically going to, clue the applicant into knowing that they didn't have a fair shake, then you're going to create liability for yourself and the city. Also be aware of conflict of interest provisions. If you were at my training a couple weeks ago, we went through those in detail. Chapter 105 has prohibited acts for quasi-judicial, for legislative, for administrative officials. The main thing to remember about that is, it deals a lot with financial interests. Remember, there are specific provisions for quasi-judicial groups, for related parties. There was a special statute just for essentially what I would say is Board of Adjustment members and who they can't they can't make decisions for, so they would need to step back and let one of the alternates come in if you've got a related party on that. Okay, let's talk about social media for just a second. Even your membership on a volunteer commission, you're not being paid, you're not elected, whatever, but that could implicate or could affect your use of social media. So if you use your social media to conduct official business, you may lose the ability to limit the content of people who are reacting to your posts. So my best advice to you is don't put matters related to your official business on social media, certainly not on your personal page. If you want to run a official page, I suppose, as a city attorney, I'm generally opposed to those too, but you should definitely separate your official from your personal if you're going to do that. My suggestion is leave it to city staff to communicate about that. I assume that you guys have a PIO, a public information officer. Let your PIO talk about what you guys have covered. You don't need to necessarily do that on your own. If you're regularly providing updates as to what you've been doing, it's possible that a court could find that you made official use of your platform. And if you do that and start deleting people's comments, you could be found violating people's free speech rights, and it would open you up to liability for doing that. That happened to former President Trump. He had a Twitter account for years and years and years that he had long before he became the president. Once he became the president, he talked a lot on social media about what he was doing as president. And when he started to block people and delete, he was found to be violating free speech rights. And you can do the same thing if you're not careful. Again, I'm extremely cautious about anybody doing any sort of official business on social media. Leave that to the city staff to take care of that. Also, if you're out there posting on your social media, that could be evidence of your prejudgment bias, and you could create liability for yourself as well. So just stay away from it. Sunshine Law. In addition to the City Council, remember that the Sunshine Law specifically applies to committees, boards, commissions, advisory committees, and quasi-governmental bodies. Yep, that covered everybody in this room, I assume. So your meetings all require notice, agendas, and minutes. And remember that your records will be subject to disclosure, which can include electronic communications like email and text. So if you are communicating with a quorum of your body, what the Sunshine Law says is you absolutely must copy that to an official city, your official city email, and if you don't have one, you need to go to the custodian of records, who I assume generally is the city clerk. So don't be talking as a quorum of whatever body you are a member of. Don't be talking about official business in that way. Definitely don't be sitting there in the middle of a hearing. What do you think you're going to do? No, that would actually literally be a meeting within a meeting in that circumstance. You're having an electronic meeting while you're having a physical meeting. So stay away from it. Understand that can be considered, that meeting without a notice. And the other thing is that any message that you send could be subject to the Sunshine Law, where you would have to actually turn them over often in many circumstances. So, okay, I only had 4 minutes, but better than last time. I ran way over. So that wraps up the materials that I have to present to you this evening. I am very happy to answer any questions that you may have. See if you can stump me. Any questions?
To what degree can a board or commission member utilize information that is not presented in the public hearing in making a determination, such as going to visit the site ahead of time, Googling the history of a developer to find out if their projects have been built or not, or whether or not the guy's been brought up on tax evasion charges or things of that nature.
Okay.
Everybody has a tendency, there's a lot of information at our fingertips. Where does all that fall within, for a public hearing especially?
Right. So I'll repeat the question just for the camera here, for the video. But the question is essentially, to what extent can you use information from outside the application, or can you do your own investigation? And I would say there is a limited ability to do that, but a lawyerly answer is it depends, okay? So if you're looking at developing a comprehensive plan, so I think where your discretion is the widest and where it's something that's more generally applicable and not specifically applicable to a piece of property or to an applicant, you have more room to do investigation on your own, to look into various things to get a better viewpoint or a better understanding of what is before you. So the further you go down the spectrum towards that quasi-judicial where you're deciding a variance or something like that, it starts to become more problematic. My best advice would be is if you need additional information and you've received the packet and you don't have that information, contact city staff immediately and ask city staff to get you the information that you need. That, again, that's what their job is. That's their calling in life, is to, their job. They want to make sure that you have all of the information necessary to make the best decision you can possibly make. Now, if you're in a situation where you decide to go out and make an investigation on your own, clear it with city staff, clear it with city attorney first. But if you've done it, to help you get a better perspective, what I would recommend is that you would disclose that during the evidentiary part of the hearing, okay? Say, okay, I was having a hard time visualizing this based on the application, so I went out to the site, kind of looked around a little bit, and here is what my impression of that was, okay? And so that's a little bit testimony in that point. You have to be careful with that though, okay? Because just because someone files an application is not an invitation to go on their property. So you could be trespassing, you have to be careful, there are certain things that if city officials are out on a piece of property, we have to go and get warrants for a reason, and even administrative warrants, apply. So I want you to be, that to me, going out to the site is not something you should take lightly, and you should find other alternatives first. But if you do it, you should disclose that at the hearing. Now, again, the further you go towards specifically applicable, working on an application, I'm more reticent to have members go out and do their own investigation. It's better to ask city staff. So hopefully that answered the question. Not everybody at once.
Well, I guess I have.
All right.
It's not really a question, I'm just gonna follow up with what you said. I usually go out all the sites. I don't go onto the property, but I can drive by. And I'm not disclosed I've been there before I vote or anything like that, so I guess I've been doing this wrong.
Well, not necessarily wrong, but what's been the purpose of you going out to the site? Why do you do it?
I think I can visualize what they're trying to accomplish better by seeing it rather than just a picture. And sometimes it's the topography and how it's going to be. And so it makes me, that's how I was taught when I came here or got on it.
Mm-hmm.
I kind of had people that the previous commissioners say that helped them.
Are you on the Board of Adjustment?
No, I'm on planning.
Planning, okay. So again, that's kind of where I was saying is, if you're planning, if you're kind of more on the higher discretionary side, the more creative side of things, which where Planning Commission tends to be on that side of the spectrum as opposed to the specific, it probably is going to be, more okay. I do think, and I'll defer to your city staff, city attorney and your community development department, as to what they would like to have you do. I'm just telling you, as a guy who represents 50-some cities out there, my preference is that my folks in your position, if they go out to the site, I would like them to say something about it in the hearing, just to say, hey, I was out there the other day, here's what I observed, because, to some extent, I am thankful that somebody does that, but don't just take that information and keep it, to yourself. Share it with your other members, because maybe they would appreciate that information, would help them make a decision too. Plus, in fairness, then it gives the applicant the ability to say, oh, well, if you were out there on Wednesday, this happened, and there was something weird that was going on that day, or something like that. They have an ability to defend themselves a little bit, or at least explain something that you may have observed that wasn't normal.
I think I normally disclose when I've been out to property.
Yeah.
So it's not like it's a secret. Right?
Okay.
And I have investigated some of the applicants. So that's the career I'm in, that, I know where they've built before, so that's kind of.
You might check with the city attorney before you do that one again.
Well, I won't say that it affected my decision.
Okay, well, hard to say.
I
Yeah.
didn't disclose that just now.
So I think they were kind of wanting people to come down to the front because we can't hear. It's not picking up on the microphone. I have these right in my face, and then he's got one back there. That's a corded one though, so you're not going to get very far. So okay. Yank. Oh yeah. I could give up one of mine, I guess.
I can speak up. So just to be clear, delegate everything to the city folks.
Yeah, city staff. I mean, and again, this is what these people do for a living, right? So, I mean, they understand, essentially, that you need certain amounts of information in order to make a decision. And I think, so they're going to present everything that they think that you need to know. And if you start, to realize that you don't have enough information, then communicate that to staff. Let them know, hey, when these applications come forward, it would really be better if we also had this. Like, you might want a topographical map or something to go along with it, depending on the type of issue that you're dealing with. If that's something that you want to kind of get is a lay of the land, So, communicate with staff, and because they just want to make your packets better. I mean, that's just innate. It's like, when you wake up someday and decide you're going to be city staff, that's just what you want to do. It's a calling.
Thank you.
Any other questions? All right. Well, that 4 minutes carried, so I'm still 4 minutes over, but I think I was 15 or 20 minutes over last time, so I did better, I think. So, well, thank you all very much for your time. Obviously, if you have questions, make sure you get that back to your city staff. Again, they truly are there to help you, make good decisions and get you the best information. I can't say it enough, obviously. So, have a great night. Thank you. Thank you.